Hi everybody, my name is Dixie Link Gordon from Mudgee Aboriginal Women's Centre. I'd like to welcome you all here to the Children DoCs and the changes to the law, which no doubt is going to impact on many people that are here in the room today, including myself. And so we're doing this this forum in partnership with Redfern Legal Centre. Well, I would like to introduce a respected elder of this here Redfern community, Miss Kay Hookie, to come up and do our welcome to country.
Good morning, afternoon. Boys, ladies, sisters. My name is Kay Hookie. Today I bring a change of acknowledgement of the land provided and respected and recognised of culture. Identify promptly a person's work of together in the community, achievements of the community. Welcome everybody to Gadigal land and acknowledge the Gadigal people of their spirits and ancestors who will also remain with the land. And we got that because I've got an itchy throat. I can't send it.
You're right.
Yeah.
This is Kay's speech that she so gladly imparted with last year, and I actually recorded it for Kay, so I'll share it with you. And it starts off, my name is Kay Hookie, an elder of our community. Today I bring a message of acknowledgement of the land and people, of respect and recognition of culture and identity, and promote a vision of working together as one community and achieving as one community. I welcome everybody to Gadigal land and acknowledge the Gadigal people of their spirits and ancestors who will always remain with the land, our Mother Earth. My Aboriginal people have been a part of this land for more than 50,000 years, and we will continue to maintain the land and continue to maintain the land of our culture and practices into the next 50,000 and beyond. I now ask everyone to look inside themselves and pay respect to our elders, both past and present, and realise the significance, the sacrifices made by our community to build a better future and to acknowledge the rich history which Aboriginal people have provided to everyone in this country. I ask people to look to the future and also see a new vision which Aboriginal people offer, a vision of hope, a vision of strength and a strong cultural identity, a better vision of a better future and a better community for all of our children, just like our elders wanted. So on that note, once again, welcome you to the land of Eora, the land of the Gadigal clan. And I hope that we work together to develop a tremendous working relationship with Aboriginal people in our community. Thank you, Kay Hookie.
Thank you very much, Anne, and well done too, along with Annie Kay, two very highly respected women within our Redfern community. Okay, so first we'd like to get on with our first speaker. Oh my God, I think I lost a page. Yeah. Also, I just want to point out to everybody, little notice, all videoing is by permission only. So unless yourself as an individual would like to share something on the video, just let Sue Ellen know over here in the striped skirt. Sue Ellen, in the lovely striped skirt. Sue Ellen has been the person who's been driving behind and preparing all this here day for us. So first I'd like to introduce Ms Cheryl Orr. Cheryl is a solicitor at the Gonslow and Co Family Law Chambers and is from the Garang people. Her family are the Williams. Garang is southeast Queensland. For any of those who may be wondering. Cheryl faced challenges when she had to leave school in Year 9 but completed a business course and later studied at TAFE, equipping herself to be employed in a variety of jobs and to offer herself for voluntary work. She felt an obligation not only to better her own position in society but also that of her community. As a mature age student, she completed a Bachelor of Social Science, Indigenous Studies and key program and Bachelor of Law as a combined degree. She then completed internships at Clayton's and Utes and at the Gorang Land Council Aboriginal Corporation, a native title representative body for the Central Queensland District. She was admitted as a solicitor in 2007, became a partner in 2009 and is currently the principal solicitor of her own practice. Cheryl's areas of practice are care and protection, family law, parenting and property. In 2007, Cheryl was awarded the National Council for Women New South Wales Australian Day Award, sponsored by the Office of Women New South Wales Premier Department. Cheryl is a member of the Law Society of New South Wales and Indigenous Issues Committee. Cheryl.
Thank you. That made me sound a bit fancy, didn't it? I'm not so sure that I am, though. In any event, I'd like to pay my respects to the elders that are here today, and I'd also like to pay my respects to the Gadigal people of the Eora Nation. I'd also like to acknowledge my own ancestors, past and present, in particular my grandfather from the Gorang Nation. Look, I've been asked to come here today, and the reason I've been asked to come here today is to speak to you people about care and protection. It's fantastic and somewhat overwhelming that there's so many people in this room, and I guess to me that signifies. I guess that signifies to me how important it is to Aboriginal people that we really tackle this issue and we make sure that we don't continue to be a statistic. Just to let you know about what I'm supposed to be here to speak to you about, and that is the changes. I was hoping when Sue Ellen did this up, and sorry, am I in the right position or do I keep moving about? A bit closer. I guess Sue Ellen was hopeful that the amendments would have already been passed, and so therefore I'd be able to speak to you about the actual impact of the new legislation in relation to what it was and what it is now. Unfortunately, the draft bill is still circulating, so the amendments.
I'm going to take that off. Sorry.
I'm not good at behaving myself, but anyway. All right, so I guess unfortunately those amendments haven't come through. Having said that, I think it's important that I can tell the community and that community knows about what it is that the Minister is trying to change in relation to the current care and protection legislation. Can I just have a show of hand who knows what care and protection is in this room? Can I have a show of hand, dare I say, of people who don't know what care and protection is in this room? Okay. All right, just for the people who don't know very quickly, care and protection is when the state comes into a family and says, we've got serious concerns about the way you're parenting your children, so because we're the state, we're going to come in and remove your children until we're satisfied there's no risk. Sometimes children go home, back to their families, because by the time care proceedings conclude, the court's satisfied or the Department of Family and Community Services are satisfied that they've met the risk. So in other words, the problems that were the reason for the removal no longer exist or are being fixed. Unfortunately, in more cases than we would want to happen, particularly for Aboriginal families, a lot of children are faced with long-term orders, which means they're not coming home, and those orders are made until the children are 18. Now, one would think, given that they've been taken away from the family, that the government would ensure, or legislation would ensure, that children had access to their families. Unfortunately, that's not so. The most likely order for children to maintain a connection with their family is between 6 to 4 times a year in a supervised environment for, let's say, no more than 2 hours on each occasion. So really, once these children have been removed, you're putting them back into the lion's den, because every time they have to go and meet their family, who they should have a connection with, it's almost like they're meeting strangers on each and every occasion, because we all know what's healthy for children's development is frequent, consistent time with people who aren't their primary carers, for them to be able to form those secondary attachments. In any event, I hope that explains now what care and protection is. Now I get back to what I'm really supposed to be here to do, and unfortunately I go off on tantrums. And that's to speak to you about what it is the Minister's proposing. So I guess the most concerning thing, and as... What's your name? Dixie. Dixie, I apologise. As Dixie said to you earlier, is that I sit on the Indigenous Issues Committee. Now, as part of the Indigenous Issues Committee, we formed a subgroup, and what the subgroup was responsible to do is to prepare written submissions about the proposals that the minister wanted to make. One of the proposals that the minister wanted to make in order to save money was that the Supreme Court, who currently has jurisdiction to issue or to authorise adoption of children, should move to the Children's Court. Now, the Children's Court in the hierarchy of our system is at the lowest of the hierarchy, and the Supreme Court is at the highest. So imagine that we as a society felt that adoption is such a serious issue that we gave the jurisdiction to the most serious court in our land, and that is the Supreme Court of New South Wales. The minister, because she wanted to save money, come in and said, well, how about the Children's Court, who is the lowest in the hierarchy of courts, should now take on adoption. Now, if you look at statistics, Aboriginal people in New South Wales make up about 5% of the total population. In care, 5 to every 1 children will be non-Indigenous. So 5 children will be Aboriginal children in care. They are, despite being only 5% of the New South Wales population, we are overwhelmingly the highest number of people in foster care. Now, the whole idea of putting adoption in the Children's Court was that if there's an order that's made for an Aboriginal child not to return home, I'll remove that, not Aboriginal. If there's a long-term order for a child that can't be returned home, the minister says that 6 months after that decision's made, that child should automatically be put up for adoption.
This is not new. Can I just say, that's not new. I've got to say that notion that was around before, and I'm talking about maybe 8-9 years ago, where at that point in time they were actually proposing that, and the Aboriginal Children's Service, in conjunction with the old New South Wales Aboriginal Legal Service, fought that proposed amendment, and it was sidelined at that point in time. And they were actually going to use a couple of cases that were test cases. So it's interesting that it's actually resurfaced. But I know that, and at that point in time, and I'll make it aware, and history, and it's not fictitious, it is fact, the organisation at the time in its infancy that was supporting the proposed changes was ABSEC.
Yep.
And I know that ALS, Limited, the old ALS, and Aboriginal Children's Service certainly challenged it, and it was sidelined at that point in time. This is quite a few years ago. So it's interesting that it's resurfaced. And of course it's about saving money.
It's about saving money. So if we look at that, and could you imagine the devastating effect it would have on Aboriginal children for them to go through the care proceedings and within 6 months then they be adopted out? It's almost, if you believe the stolen generation stopped, which I guess I'm sceptical, I don't, because I work in the care and protection jurisdiction, so I watch it every day. But if you are a believer in, yes, we've the government's amended their ways, we make sure that the stolen generation doesn't continue, certainly I would advocate that these new amendments, had they have been passed, or if they are passed, is another way of creating a stolen generation, whether you be black or white. However, having said that, I advocate for a black voice, so I'm a black voice for my people. I don't get involved in what's happening for non-Indigenous children, and I'm sure there's lots of people that take up that fight, but that's not me. So a part of my job on the Indigenous Issues Committee is that when we were attending roundtables, we were totally opposed to Aboriginal children even being part of the suggestion that they should be included if that new amendment was passed. We had written confirmation to the Indigenous Issues Law Society prior to the proposed amendments being circulated that Aboriginal children would not be included in any proposals for adoption. So that's great. So that's been stopped. Unfortunately for non-Indigenous children, that was an issue that continued. That was a proposal that went. I can say the draft bill is out. I'm not at liberty to speak about that draft bill, but it does look like that common sense has prevailed, and that those in high places have agreed that the jurisdiction of adoption is so important, is so special that it should be left to the experts, and that's the people in the Supreme Court. So it doesn't look like, thank God, that amendment will be passed, so it's included in the care and protection legislation. One of the other big issues is what they're trying to do is to curtail contact. contact orders. Look, contact was something fairly new to the care and protection jurisdiction. The care and protection, so the Children's Court started in about 1970, and then the Act come in, obviously to enact the Children's Court, and then obviously over the years there's been amendments and reworking of the Act. Around the 1980s, there was strong advocacy for contact to be included in the Act. Prior to that, there was no contact orders. So if a child was placed into foster care, the only way a family could have contact with that child is if the Department of Family and Community Services, whatever they were called back then, gave permission for that to happen. Which is not unusual to really what continues to happen unless you specifically ask, and everybody should specifically ask for a contact order. There's currently provisions in the Act that allow for contact orders to be made similar to what would happen in the family court. However, it's not as generous as the family court contact. However, you can push to ensure that you're having this continuous, frequent relationship with a child, particularly if you've got somebody from the family who's willing to supervise and they'll be assessed to be suitable to supervise. So it's insofar as keeping connection with family, particularly for Aboriginal people, that contact order is something really, really important, because it may be, for whatever reason, your clients aren't up to scratch on the day the hearings ran. However, they've been trying along the way, and they really need, they want to keep contact with baby, or they want to keep contact with the child they've parented for 7 years. That child needs, more importantly, the child needs to keep contact with the parent. So you ask for a specific contact order, and you might put forward aunt, you might put forward uncle, gran, great aunt, whoever, to supervise that contact, and the court may say, look, they're fine. I'm happy rather to give the normal 4 to 6 times a year. I'm going to give you 12 times a year, so once a month plus special occasions. So you end up with an order where you had that contact order not been in place, the care plan says 4 to 6 times a year, but you've now got a contact order that says somewhere between 12 to 18 times a year. Very, very important provision of the Act. Because of, again, funding, the department have taken on the view that it's really, really expensive for us to be organising contact, and, contact orders are really just something that's, I guess, making us spend more funds than we need to. So what we're going to do is we're going to curtail the Act, and they wanted to make, what the Minister's idea is to exclude contact altogether, so take it away. So there's no option whatsoever for any contact orders to be made by the Children's Court. Now, there was lots of submissions from the Indigenous Issues Committee, the Family Law Issues Committee, the Bar Society of New South Wales, community legal centres. Lots of voices spoke out about this and said to the Minister, you seriously can't, table this. This is not okay. You're curtailing, people's rights to have a connection with family. The Minister come back, I guess, what she thinks is a compromise, and what she's proposing, and unfortunately looks like will pass, is that the Children's Court at first instance, so in other words, when they're hearing care proceedings as to whether or not a child should or shouldn't go home, they can't hear contact proceedings, so it won't formulate part of the proceedings. That if people are not satisfied with the contact that's being offered in the proposed care plan, that the care plan that they have to go off to FDR, which is Family Dispute Resolution, which is like a mediation service, and they have to try to come up with an arrangement in FDR. If then they don't come to an arrangement in FDR by consent, you can then file separate proceedings in the Children's Court, but the maximum order that the court can make in relation to any contact will be curtailed to 2 years. Now that means, say a newborn bub will be allowed to have, if a contact order is made, a relationship with mum or dad, or mum and dad and extended family for 2 years, but after that, pretty shocking, I would say. Absolutely outrageous. Who knows? I mean, if it's private FDR, we wait in the family law proceedings, we wait anywhere between, 3 to 6 months to even get a mediation date. Who knows? I'll just finish my topic and then I'm going to ask for questions. Sorry to shut everybody off, otherwise I'll go on my tantrums again. I guess I have more concerns as well, because what they're doing is Family and Community Services are outsourcing all of out-of-home care. So all of out-of-home care will go to private organisations. Now, that means that private organisations who don't necessarily know the Act, who don't necessarily know the family, who really are there to have these children placed in out-of-home care with foster carers, will be deciding without any transparency whatsoever what contact the child will be having with its parents. Now, it's my experience, unfortunately, that human nature kicks in, and sometimes purely a difference of opinion with a character of a parent and a private caseworker, even a DoCs caseworker, will cause terrible rifts and will cause decisions to be made that aren't necessarily in the child's best interest. The saddest thing about that is that there will be no recourse for a parent to argue, look, this is just a matter of personalities, rather than a non-government organisation or Family and Community Services deciding that contact has to stop. Now, I've been in matters myself whereby I've had to commence proceedings because DoCs have just decided they're going to stop contact because it's in the child's best interest, without bringing a matter back to court, because they were of the opinion they had PR, notwithstanding it was in a care plan stating what contact, in one particular case I have in mind, what contact the paternal parents were having with this particular child. Because there was contact orders still in the Act, I was able to bring an application and I was able to formalise the contact that the grandparents in this particular case were having with the child, which was fortnightly contact. Now, because the contact orders are going to be, are more than likely going to be amended and curtailed, that won't happen in the future, which is really sad. Does any questions? Somebody was putting up their hand.
Is it possible for people to apply again for new contact orders after that 2 years?
It doesn't look like it. Yeah, so that's when I say it'll be a 2-year order and that's it. Yeah, it's a one-off. Stolen generation. Here, sister.
What can we do about it?
Look, the problem. Well, when we were doing these submissions, we said there needed to be a green paper on the issue. And there needed to be community involvement about what's happening before these amendments went through. The Minister was of the opinion, no, we had no time. These have got to be put through in the spring session, and it wasn't done. So you know, in a democratic society, the answer is now probably nothing.
What about the court orders that are in place for?
Big voice.
What about the court orders that are in place now? You know, because I've got to suddenly be out of home care until he's 18, and I have visitation rights for once a month until he turns 18. Are they going to change or not?
No, they'll stay. So because they've already been made, they can't be changed.
2 questions. I have a child in care, unfortunately, for no particular reason, and I've been a long struggle to get further contact, and I want more contact. I want my child back, of course, and also what is the point of changing? Like you say, DoCs are for the care and protection, and it's the best interest of the child to keep contact with their parents and so forth. Yet they're taking away even more rights, if we have any at all. Like most people don't even know what rights they have left when this sort of thing happens.
I agree with you. If I can go back to,
It's hypocritical, really. It's very discouraging.
Look, anybody who knows me, unfortunately, if you're from the Department of Family and Community Services, I mean you no disrespect, and obviously the service is there for a reason. Anybody who knows me knows very clearly my passion in relation to being anti-family and community services. I'm not here to say to anybody, I don't apologise for the way that I feel, but I'm not here to say to anybody it's not a necessary organisation. It is. My difficulty with family and community services is, in my experience, once it gets to court, what they do with it then. Unfortunately, they're hell-bent in, long-term orders, rather than, let's support. There's some cases, particularly in Aboriginal matters, where I can tell you the matter goes to court with 211 risk of harm reports. To family and community services, intervention is happening for the very first time when the matter's filed before the care court. That's outrageous. What's happening that family has got to that point? Where is the support prior to those reports coming in and then being, not classified as urgent enough? If there's reports, there's reports. Put supports in place. It's a different case if we're saying, yes, the supports were offered and the people didn't engage, but I'm talking about cases where there is absolutely no engagement whatsoever.
But that's the problem with the system, and with all due respect, we were one of the founding members I'm one of the founding members of the Aboriginal Children's Service, which no longer exists because the funding was withdrawn. When it comes to, children's issues, and no doubt Linda Dang will remember, is the most sensitive issue that can impact on any individual, be you Aboriginal or non-Aboriginal. And 9 times out of 10, in defence of some of those DoCs workers, they're damned if they do and they're damned if they don't.
Same here.
I understand. I understand both sides don't get me wrong, because I've been there. Right? As I said, I'm one of the people that was there that helped set it up in the late 70s. And that organisation was a major instrument that will bring about change here in New South Wales and indeed Australia when it comes to looking at care and protection of Aboriginal children. But what we've done is we've gone through these different phases of how we're to supposedly deal with children that need to be removed. And the sad reality, and a lot of the dedicated men and women that were associated with the Aboriginal Children's Service that have now gone on to work in other agencies, and a lot of them, by the way, passed over, all they ever wanted to do was look at preventative programs. That was the key and the essence of that organisation. The sad focus has shifted and it's been along the line of intervention. So if we go back to prevention and get serious about preventing and putting resources in to supporting parents, because we all fall over at one stage in our life. There is no one in this room that walks on water, no one. And we all fall over through circumstances that have, in some cases, a profound impact on us. And circumstances certainly do break people, But what really worries me is we've got parents of children that they serve more than, they serve life sentences, You don't go to jail for the length of time that some parents have had to serve for the kids being removed. And I'll say this, that there are different mechanisms. Children are removed for one reason or another. And there is a difference between children being forcibly removed and a difference between children being adopted. And in my culture, as part of my people, we don't adopt our kids out. That's not a part of our culture. That's right. And I don't know about other nations, but you cannot, by virtue of the pen, wipe out the biological parents of those children. We have surrogacy. So the way that things are moving, you talk about another stolen generation. That stolen generation's been, it's never gone away. And it's how we actually deal with it now, and hopefully and pray that the powers that be are going to be realistic about where we go to. So, the power will come from the people about what needs to be implemented, and I'm dead set serious. We've really got to get serious about prevention rather than intervention. Because intervention, doors is already bolted, and believe me, some of the Aboriginal and non-Aboriginal people working DoCs, they're not the enemy. They are not the enemy. They are dead, and I'm dead set serious. I'm not saying that just because I work with that. If I tell you I work with some Woodens and I work with some Deddies, and we challenge those Deddies. And if I lose my job over it, then so be it. Because I am who I am. I'm no longer a spring chicken. But I say that we've really got to get serious about prevention, and it is tragic. If they're going to go down the path after 2 years of denying contact, that's when a lot more problems are going to actually emanate. They'll come up through the surface, and we're going to be dealing with a lot of broken kids, but more importantly, broken souls that are parents that are never ever going to even look at getting them back.
And they need to be aware of it, they need to be careful of it, and they need to take responsibility for what is happening in the care and protection jurisdiction. With the greatest respect to you, I'm here to promote that my people as a people need to get together as a community, and we have to make sure that we don't even get to the care court. So how we do that, guys, is we reach out for help before it becomes a tragedy. You know, if you see something's going wrong in the community, step in for your sister, step in for your brother, step in for your niece, step in for your nephew, step in for your granddaughter, you know, and go and file in the family court, because it'll be a completely different outcome. You can take on parental responsibility for a short term while your family member is getting their act together, and despite the family court in location being directly across the road from the children's court, despite this, you know, two jurisdictions operating in this land concurrently, they have two completely different outcomes, and they are both based on what's in the best interests of the children. Because I can assure you people, through my own experience, not only my individual experience, my personal experience, but also my vast experience as a practitioner, those children who are at risk one moment with their parents because you've stepped in to put your hand up and take responsibility for those children at that time will go home to their parents, because unlike the care and protection jurisdiction, the family court gives parents time. They give parents time to get their act together, including ma'am from Family and Community Services, including allowing proceedings to be suspended while a parent goes to a long-term rehabilitation for 18 months. So maybe while you're here in this community, here at this gathering, perhaps from Family Community Services, you can tell me and these people here, because I don't even know, and I'm a lawyer. Anyway, my message to the community is that if you see risk, rather than let it become a care statistic, get it into the family court. Someone put up their hand in the family who's able to step in to take parental responsibility for a short period of time while your family member's getting their act together. It doesn't have to be another statistic. Look, on that note, there's one more thing I want to just quickly say to you, and it picks up from Arne over here in relation to prevention rather than intervention. To the credit of Family and Community Service, one of the interventions, one of the amendments they're trying to make is early intervention. Let's hope that actually is prevention rather than intervention. So what they're going to do now is they recognise that they need to put more funding rather than in the removal stage. They need to put more funding into trying to prevent the removal stage. Now, what they're proposing is to set up more NGOs, so non-government organisations. Specifically, what's important to us is that they're looking at funding more Aboriginal organisations. If that happens, that's fantastic. My concern is that you also need to be careful that the NGOs are going to be given powers that enable them to sign you up on contracts. Contracts are a legal document. The NGOs aren't lawyers. You won't have the benefit of being able to get advice from a lawyer as to whether or not you should sign it. You won't necessarily have a lawyer's advice in relation to telling you the pitfalls of what you are signing. Should you not fulfil the parenting contract at the time? So, for example, you go yourself, you say to an NGO, look, I think I've got some problems, and they say, okay, look, it's great that you've come, thank you very much, let's sign you up on a parenting contract. You sign up on that contract, along the way you decide, I no longer have any problems, but the NGO's of a different opinion. You stop engaging with the NGO, thank you, you now become a care proceeding. You now become a statistic in the care proceedings again. So, credit to the department for recognising there needs to be early intervention, and I hope, Aunt's words, beautiful words. I hope it's not intervention per se, but more prevention. And we see a shift. We see a shift in the amount of kids that are going through the care and protection jurisdiction. unfortunately for me, I would say to all of you in the community, if you engage with an NGO and you're asked to sign in the future, if you're asked to sign a parenting contract, it is a contract. It's not just a piece of paper that's going to let you keep your kids for a little while longer. You have to engage, and more importantly, before you sign it, go and get some legal advice. Go visit ALS, go visit legal aid. Ring up a solicitor who you know is ring up me. And take my afternoon up so I can tell you about the pitfalls and do a letter in response just to make sure that you're safeguarded. I hope I haven't spoken over time, have I?
That's been great, thank you.
Okay, so.
There we go. Hi Cheryl, sorry they haven't bloomed yet, but you're certainly blooming. Thank you very much.
Thank you.